Welcome all. I am Taruna Reni Singh, Assistant Professor, Faculty of Juridical Sciences, Rama University. Today, we shall be discussing Article 12, which deals with the definition of state under Indian Constitution. The fundamental rights of the Constitution are guaranteed under Part 3 of the Constitution. Now, this part is considered as the Magna Carta of India. Now, this Part 3 of the Constitution, that is the fundamental rights, substantially covers the civil and the political rights which are guaranteed under the Universal Declaration of Human Rights. Now, B.R. Ambedkar considered this part as the most criticized part of the Constitution, whereas Justice Gajendra Gadkar considered as this part as the foundation and the cornerstone of the democratic way of life which has been constituted in our country through Indian Constitution. The concept of state action, it is not defined in the Indian Constitution, but it is implied in Article 12 of the Indian Constitution, which reads as, in this part or unless it otherwise requires, the definition of state includes, first, the government and the Parliament of India, second, the government and the legislature of each state, third, the local authorities and other authorities within the territory of India or under the control of the government of India. Before we get into the discussion of the definition of Article 12 under the Indian Constitution, we shall first look at the constitutional history. Now, the same article was mentioned under Article 7 of the draft Constitution. The object of defining this article was that effective enforcement of fundamental rights. Dr. B.R. Ambedkar was the one who advocated the retention of this article so as to claim the fundamental rights against anybody or authority which exercises control over the people. By authority, he meant any authority which can make law or has been vested with the discretionary powers. Now we shall move forward with the definition of Article 12 mentioned under the Constitution of India. The definition states that in this part, unless it requires, the state includes the government and Parliament of India, the government and legislature of each states, the local authorities, other authorities within the territory of India or under the control of the government of India. The first 2 points are self-explanatory. Government and Parliament of India, it talks about the Union Executive and Legislature. In the case of Shreya Singhal versus Union of India, Section 66A of the IT Act was challenged due to the violation of Article 19. Local authorities includes municipal committee, district board, board of commissioners, etc. Now, these authorities should be entrusted or entrusted legally by the government the control or management of the fund. Now, we shall discuss the meaning of the term other authorities. The judicial interpretation of the term other authorities has been defined through various tests. The first test that was devised by the Supreme Court was the test of justum generis, which means of like nature. Only authorities consisting of like nature of the character of governmental power shall be included in the term other authorities. Now, this test itself was a vague test, and therefore, this case University of Madras versus Shantabai was overruled by the case of State of Maharashtra versus Ujjainbai. Now, according to the court, only those statutory or constitutional bodies can be considered as state which possesses the power to make laws or which can issue binding direction, disobedience of which could lead to punishable offences. The meaning of the term instrumentality is the means or the agency through which the functions of any other entity is accomplished. The meaning of the term agency is the fiduciary relationship by express or implied contract or by law. The test of agency and instrumentality was put forward by Justice Matthews in the case of Sukhdev Singh versus Bhagat Rao. The case of Rajasthan Electricity Board versus Mohanlal acted as a precedent in the case of Sukhdev Singh versus Bhagat Rao, wherein it was held by the Supreme Court that the corporations are state. Why? Because they had the origin of the statute and were given powers to make laws. The fourth test that was devised by the judiciary was the government control test. In the case of R.D. Shetty versus International Airport Authorities, the judiciary gave a 5-point test. The first point, financial resource of the state, that means the chief funding is given by the state. The second, deep and persuasive control. Third, the governmental character, which means that the character should have some public importance. Fourth, the department of government transferred to a corporation. And fifth, that the corporation enjoys monopoly. When these 5 points are satisfied, then that corporation becomes a state. The 5 test is an illustrative and not a conclusive one, therefore should be used sparingly. Now, Justice Bhagwati extended this explanation in the case of Ajay Hasya versus Khalid Mujib. The first 5 points of the previous case and the 6th point, that is the public importance, was explained by Justice Bhagwati in the case of Ajay Hasya versus Khalid Mujib. For a corporation to be state, these 6 points has to be met. The 5th test that was devised by the judiciary to interpret the term other authorities under Article 12 was the deep and the persuasive control test. In the case of Pradeep Kumar Biswas versus Indian Institute of Chemical Biology, the Supreme Court held that the body should be dominated functionally, financially, and administratively by the government and should have the control, deep and pervasive control, not just mere regulatory control. Now we come to the question whether judiciary is state or not. In India, it is undisputed that when the judiciary is performing an administrative function, it is bound by the fundamental rights of the Indian Constitution. Now we come to the question that whether judiciary comes under the definition of state or not. The judiciary performs 2 types of functions. First is the judicial function. Second is a non-quasi-judicial function. That means when the judiciary is performing a quasi-judicial function, then the judiciary is included in the definition of the term state. In the case of A.R. Antale versus R.S. Naik, it was held that the judiciary, when performing the quasi-judicial function, is included in the term state. So friends, I hope now you will be able to trace the judicial interpretation of the word other authorities which is mentioned under Article 12 of the Indian Constitution. Thank you for joining today.